All right, we're successfully on live stream, so that part is done. Well, let's see. Do we have Trevor Ferreira? Not yet.
Your Honor?
Yes.
Mr. Ferreira is part of our defense team. And I believe that Scooter the prosecution is competing in this tournament.
Okay. Let's see here. So I am. Okay, so Scooter. Want to make sure we're not leaving everybody out here. So Scooter is prosecution, Miss Piggy is defense. Is that correct? Okay, I see a lot of nods. Okay. Well, I think get to my. Okay. There's one more person wanting to join in. You know, it might be easiest here. Somebody could speak up for prosecution. Are all of your teammates here and ready to proceed?
One moment, Your Honor.
Thank you.
Yes, Your Honor. The state is ready to proceed.
Perfect. And is everybody here from defendant's side and ready to proceed?
Not yet, Your Honor. We are missing one of our participants.
Okay, we'll hang tight.
Would it be possible while we're waiting to get the roster of all the participants for both teams so we know which student attorney or student witness is taking each role?
Yes. And I think what we'll do Is it acceptable to upload those into the chat function? Or how are those typically shared? Do you know, Jennifer?
In my last run, they were shared in the chat function.
In the chat function, perfect. Then let me just share the ones that I've received, and we'll upload them, and then everybody can tell me if those look accurate. If I can actually share them, or save them rather.
Your Honor, all members of the defense are here. We are ready to proceed whenever you are.
Thank you. Let me just finish uploading this roster really quick. Let's see, we've got Miss Piggy's roster up there, and Scooters is now in the chat room. Okay.
Right.
Scoring panelists, scoring judges, have you received the roster? Does everything look okay there?
Yes, I believe so.
Perfect.
Yes.
A lot of these instructions that I have, I believe, are for in-person trial practice. So some of these, I'm going to read them anyway, just to make sure we're complying with all the rules. But bear in mind that some of these simply aren't going to apply. I'd like to confirm that if anyone is video recording these proceedings, that you can only do so if both teams have approved the taping of the round. That, of course, is that applies to everybody, both student participants and anybody else. Need to inform the teams as well as all gallery members that the Colorado Bar Association may be taking photographs of the competition during the round, and that team participation in the state tournament grants automatic permission and the use of these photos by the Colorado Bar Association. If anyone is in the gallery who is connected with teams not competing in this round, please leave the courtroom unless you fall under one of the exceptions, which I will not go over. Like to remind the teams that no recesses are allowed during trial, with the exception, of course, of a health emergency. But particularly, particularly, they are not allowed between the end of witness examination and the beginning of closing arguments. We have everybody in the courtroom. The scoring panelists, do you know any of the student participants or have any reason to believe that you might be biased in judging either of the teams?
No.
No.
Okay, and I do not likewise know any of the participants and am not biased in the judgment of either team. So I'd like to remind teams and coaches that any disputes arising out of this competition must be reported in accordance with the competition rules. I remind the teams that their compliance with time requirements will be considered in scoring individual performances this evening. I'd like to confirm that we don't have any coaches or team members seated in the jury box. We don't have a jury box. And prosecution, if you would like to introduce your team members, including who will be the attorneys and the witnesses, please.
Yes, Your Honor. Good evening, Your Honor, members of the jury, opposing counsel. My name is Brianna Hush, and today I will be delivering the opening statement on behalf of the prosecution, conducting the direct examination of Kyle Kuzak and the cross-examination of Taylor Perkins.
Good evening. My name is Jasper Bloom. I will be conducting the direct examination of Alex Cifuentes and the cross-examination of Professor Blake Van Owen.
Good evening. My name is Annaluna Grant. I'll be conducting the direct examination of Detective Jordan Markowitz, the cross-examination of Avery Becker, and delivering the closing argument on behalf of the prosecution. May our witnesses now introduce themselves?
Please.
Good evening. My name is George Bradley, and I am Detective Jordan Markowitz.
Good evening. My name is Ellie Musfeld, and I am Kyle Kuzak.
Good evening. My name is Tristan Med, and I am Alex Fuentes.
All right. And would the defense like to introduce themselves?
Yes, Your Honor. Good evening, Your Honor, members of the jury, opposing counsel. My name is Kayla Caniglio, and I'll be conducting the opening statement on behalf of the defense, delivering the direct examination of Taylor Perkins and the cross-examination of Kyle Kuzak.
Good evening, Your Honor, members of the jury, opposing counsel. My name is Rima Baisha. I'll be conducting the direct examination of Professor Van Owen, along with the cross-examination of Detective Jordan Markowitz.
Good evening, Your Honor, members of the jury and opposing counsel. My name is Taryn McDermott, and I'll be doing the closing argument, as well as conducting the direct examination of Avery Becker, as well as the cross-examination of Alex Fuentes. I now ask if the witnesses may introduce themselves.
Of course.
Good evening. My name is Anna Ensley, and I am Avery Becker.
Good evening. My name is Josh Ryan, and I am Taylor Perkins.
Good evening, Your Honor, members of the jury, opposing counsel. My name is Yash Deshpande, and I will be playing Blake Van Owen.
All right. Welcome, everyone.
Well, hold on, Your Honor.
Yes.
The names that everyone just introduced themselves, the names aren't matching what's on the roster. Is that?
I was suspecting the same thing when I was looking at the rosters. Yes, Jennifer?
It's page 2 of each roster. It's a 2-page document. I think the page 1 is round 1, and then the second page is round 2.
Oh,
look at that.
Okay. It's my error then. Okay.
It was mine as well. Thank you for clarifying that and pointing that out. Okay, welcome everyone. We're going to go through the swearing in. I'll do the team members first, then the witnesses, gallery members. I believe we might have a couple, and then the scoring panelists, and then we will rock and roll. Team members, please raise your right hands. Team members, do you promise that the presentations you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? Witnesses, please raise your right hands. Do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? I see a lot of nods. I'll take those as yeses. Gallery members, including teacher and attorney coaches, family members, and friends, please raise your right hands. This includes everyone watching on the live stream. Do you promise to present yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? I see no nods, but that's probably because everybody's on live stream. Finally, scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes.
All right. Let me just go through my instructions really quickly to make sure I am not missing anything. I do ask everybody, if you are not currently participating, please turn off your videos. Make sure you stay muted. I am going to change my view to make sure that I have no non-video participants. Well, theoretically, I was going to change my view to that, but I don't have the option it says. So as I am the judge, I am going to just keep it the way it is. Prosecution, are you ready to begin?
The prosecution has a few pretrial matters, Your Honor.
Let's start with preliminary matters. Go ahead, Counselor.
Thank you. Now, in recognition of our virtual format, pursuant to Rule 5111, we are requesting permission for attorneys to remain seated during statements, objections, and examinations. We mean no disrespect by this, but due to our current format, we felt that it might be necessary.
Makes absolute sense. And I would actually note that even if we were in a normal courtroom these days, when you have in-person hearings, everything is done seated. Nobody's standing at the podium and everybody's wearing masks. So permission granted. Thank you for bringing that up.
Yes, Your Honor.
Anything else?
Yes, Your Honor. When we are entering exhibits, may we constructively screen share them with the witness to authenticate and lay foundation for their eventual admittance? And then when they are admitted, may we constructively publish them to the jury?
Yes, I think, well, let me see. Defense, do you have any objections to that?
The defense has no objections to that, Your Honor.
All right, so granted. Anything else for the prosecution on preliminary matters?
Yes, Your Honor. Pursuant to Mock Trial Rule 203, permission for witnesses to use the Zoom functions to annotate the exhibits after they've been entered.
Defense, do you have any objections to that?
The defense has no objections to this, Your Honor.
All right, so ordered. Anything else?
Yes, Your Honor.
Okay.
We hope this will not happen, but in the event that someone loses their Wi-Fi connection, may they contact their teammates via text to inform them of what's going on?
Yes, and this is for both sides. If somebody, I'll just read that into the record. If somebody loses connectivity, then communication by text is acceptable with teammates to let them know they're getting back on, and then the teammates can then communicate that to the court. Otherwise, no communication by text will be allowed. Understood?
Yes, Your Honor.
Okay. Anything else?
Yes, Your Honor. The prosecution would like to reserve any remaining time in our closing argument for rebuttal.
Okay, let's go ahead and we'll deal with that when we get to closing arguments.
Yes, Your Honor. The state is ready to proceed.
Okay, and defense, do you have any preliminary matters beyond those we've already discussed?
Yes, Your Honor. The defense asks for the same as the prosecution, and that the jury instructions be constructively read into the court.
Prosecution, do you have any objection to the jury instructions being constructively read into the court?
No objections, Your Honor.
So ordered. Anything else?
That is all, Your Honor.
All right. Prosecution, when you are ready, we can start opening statements.
Yes, Your Honor. Your Honor, members of the jury, today the evidence will show you that the defendant has gone too far. On March 6th of 2020, the victim, Mackenzie Brackman, was in his house on 444 South Flower Street. It was a Friday afternoon, and Mr. Brackman was relaxing before he needed to go to his mock trial practice that day. But Mr. Brackman never made it to that mock trial practice. And as you'll learn today, That's because of the defendant, Avery Becker, who's a former member of Mr. Brackman's mock trial team. Now, the defendant went to Mr. Brackman's house on that same Friday. And while the two of them have never gotten along well, we expect you to hear today that it all came to a head on that March 6th. Because on March 6th, 2020, the defendant made the decision to break into Mr. Brackman's home, a break-in that went wrong and led to Mr. Brackman's death. My name is Brianna Hush, and I, along with my co-counsel, Jasper Bloom and Annaluna Grant, represent the people of the state of Colorado. This is a case about a feud that has gone too far, about a series of disagreements between a coach and a student that ended in a murder. We expect you to hear the details of those disagreements here today in court, and how, as the tension built, the defendant's escalating reactions led to Mr. Brackman kicking the defendant off of the mock trial team. However, we can't just tell you that it was the defendant who murdered Mr. Brackman. As the prosecution in today's case, we must prove that on March 6, 2020, the defendant unlawfully entered the dwelling of Mr. Brackman with the intent to damage Mr. Brackman's personal property, and while committing that crime, he caused the death of Mr. Brackman. Now, to prove this, we're going to call 3 different witnesses to the stand today. First, you'll hear from Detective Jordan Markowitz, a homicide detective who's worked with the Denver Police Department for 13 years. Detective Markowitz will walk you through the police's investigation, and he'll explain how he used his specialized training in cellular data analysis to uncover evidence that points straight to the defendant and only to the defendant as the suspect in today's case. When Kyle Kuzak takes the stand, you'll learn about the details of the attack itself. Ms. Kuzak is a crime scene reconstruction investigator with 19 years of experience, and she will tell you what happened on that fateful Friday at Mr. Brackman's house, starting with when the defendant first arrived on Mr. Brackman's property and ending with Mr. Brackman's death and the defendant's escape. You'll also hear from the defendant's long-term teammate, Mr. Alex Cifuentes. Today, you'll learn about the text messages Mr. Cifuentes received from the defendant right before the attack, laying out the defendant's plan to get Mr. Brackman back by breaking into his house and trashing it. Now, the defense will try and convince you that someone else committed this crime, but they'll have nothing but speculation to back this up. They'll call in the defendant, who we expect will attempt to disprove Detective Markowitz's case. But listen closely and you'll hear her admit that she conveniently lost her phone the day before the murder. Now, the defendant's best friend, Taylor Perkins, will back this story up, but we expect Mr. Perkins to admit that despite the fact that the defendant considered her phone to be like a third kidney, she apparently didn't notice her phone went missing until Mr. Perkins personally asked her about it the next day. You'll also hear the testimony of a private investigator, Professor Blake Van Owen. Still, keep in mind that Professor Van Owen only spent 9 months in the police force before leaving it due to his own misconduct as a police officer when he went too far in an arrest and injured a civilian. By the end of the trial, we will have proven beyond a reasonable doubt that on March 6th, the defendant went too far when she broke into Mr. Brackman's house, intending to wreck the place, yet ended up murdering Mackenzie Brackman instead. We will have proven that the defendant stabbed Mr. Brackman in the back, then ran away, leaving Mr. Brackman to die alone by his own front door. Members of the jury, all these reasons are why at the end of this trial, we will ask that you find the defendant guilty of second-degree burglary of a dwelling and murder in the first degree. Thank you. Your Honor, you're currently muted.
Thank you very much. Defense, are you prepared to present your opening statement?
Yes, Your Honor.
Please proceed.
May it please the court? Your Honor, ladies and gentlemen of the jury, opposing counsel. My name is Kayla Cniglio, and I, along with my co-counsel, Rima Baesha and Taryn McDermott, represent the defendant, Avery Becker. After a rushed and negligent investigation, my client, Avery Becker, was accused of murder in the first degree and second-degree burglary. Members of the jury, these are serious charges. And today, you will hear about a case of how negligence coming from arrest investigation will lead to a ruined life. The prosecution bears the burden of proof, so they must prove each element of these crimes beyond a reasonable doubt. If you have any doubt or that the prosecution has failed to meet their burden, and you must find Avery Becker not guilty of these crimes. Today, the defense will show you significant pieces of evidence overlooked by the prosecution that cast significant doubt over the conclusions that they have drawn. We will also mention another suspect who has a much more plausible motive to have committed this crime. And today, you will hear about the accusations based on negligence coming from a rushed investigation that will lead to Miss Avery Becker's life being ruined. Today, the defense will call 3 witnesses to the stand. The defendant, Miss Avery Becker, her close friend and teammate, Mr. Taylor Perkins, and Professor Blake Van Owens. Today, you will hear Miss Avery Becker testify to her whereabouts during the day of the murder and who she was with the entire time. She will then speak to her own connections with Mr. Cifuentes and the victim. Then, Mr. Perkins will take the stand. He will reveal that he was with Miss Becker for the entire day in question, with neither of them being anywhere near Mr. Brockman's house, with neither of them even knowing where that is, before speaking to his own connections with Mr. Cifuentes and the deceased. Then, Professor Blake Van Allen will take the stand. He will show, through the evidence, that the conclusion drawn by the prosecution is not the most logical one. He will show you that the evidence he has been provided points to a different course of events than the prosecution has indicated. He will show the problems of using cell towers to track a person's location, as well as speak to another potential victim potential suspect that was neglected to look at through the prosecution's investigation. Today, we will show you that the victim's right hand shifts, a fact that both Detective Markowitz and Kyle Kuzak neglected to place in their reports. You will then see the report of Kyle Kuzak, who names Alex Cifuentes as a second suspect in this crime. In addition to this, Mr. Perkins and Miss Becker will show the bias held by Mr. Cifuentes, and that his actions are not as just a teammate or friend, but as a rival. They will also show the bias that is held against Miss Becker and the bias that favors the other potential suspect. Then we will show that Detective Markowitz neglected to look at several facts in this case, and this influenced the information given to Miss Kuzak, the crime scene reconstruction investigation. Today, ladies and gentlemen of the jury, we will show that the negligence of the prosecution is going to lead to Miss Avery Becker's life being ruined. The defense will use the evidence provided to show where the prosecution fails to prove several crucial points and poke holes in the burden of proof that they bear, while reminding you that Miss Avery Becker bears the presumption of innocence in this case. Ladies and gentlemen of the jury, Avery Becker, Taylor Perkins, and Professor Blake Van Allen will show that the justice for both Miss Becker and Mr. Mackenzie Brockman needs to be upheld despite the negligent and rushed investigation from the prosecution. After hearing all of the evidence today, the defense asks that you find Miss Avery Becker not guilty of first-degree murder and second-degree burglary, so that another innocent life is not ruined by this tragedy. I will remind you that on March 6th, 2020, Mr. Mackenzie Brockman, the coach of the mock trial team, was murdered, and his killer burglarized his dwelling. These facts are disputed by neither side, and it has been since then that the prosecution has indicated that it was Miss Becker. But once again, we will show through the evidence that this is not the case, and that Miss Avery Becker is not guilty of either of these crimes. Thank you.
Thank you. Prosecution, are you ready to present your case in chief?
Yes, Your Honor.
Please
The prosecution
proceed.
calls, sorry.
Please proceed with your first
The
witness.
prosecution calls Detective Jordan Markowitz to the stand. Good evening. Please introduce yourself to the jury.
Good evening. My name is Detective Jordan Markowitz.
What is your connection to this case, Detective Markowitz?
I was the first detective on the scene after police officers had cleared it.
I would now like to talk a bit about your background and qualifications. Where are you currently employed?
The Denver Police Department.
For how long have you been working at the Denver Police Department?
About 13 years.
And for how long have you been a homicide detective?
Roughly 7.
Within your career as a homicide detective, do you have any other experience?
Yes, I also have a specialization in cell phone technology and data recovery.
Have you received any certification for this training?
Yes,
Or this specialization, rather?
I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement.
What did this training equip you with?
All knowledge related to cell phones. I know how to gather and interpret data from cell phones and cell tower records, as well as how to apply this data to cases.
Has the certification been useful in your career thus far?
Absolutely. I've downloaded the contents of literally hundreds of cell phones and have actually downloaded the contents of cell tower records and cell phones for over 50 cases.
Your Honor, at this time, I now move to enter Detective Markowitz as an expert in crime scene investigation with a specialty in cellular data analysis under Rule 702.
Does defense have any voir dire?
Yes, Your Honor, I'd like to conduct a short voir dire.
Please proceed.
Good afternoon, Detective Markowitz.
Good evening.
Oh, excuse me. Good evening. You mentioned a 3-day training course. Isn't it true that these 3 days are the only formal training you've had in cell phone technology?
I have quite a bit of experience, but I do only have 3 days of training.
And it was during these 3 same days that you received your only formal training in forensic data recovery as well, correct?
That's correct, yes.
Thank you, Detective Markowitz. Your Honor, I have no objection to Detective Markowitz testifying as an expert in the fields requested by the prosecution, but I request that the detective not provide expert testimony in relation to cell phone technology or forensic data recovery, as the prosecution has not provided evidence of sufficient training or experience in these fields.
Prosecution, do you have any response to that?
Yes, Your Honor. Under Rule 702, in order for a witness to be qualified as an expert, they need to exhibit knowledge, skill, experience, training, or education. And Detective Markowitz has exhibited all of these throughout his career. He also does have training regardless of how long it was. He has received formal training that would allow him to testify about matters regarding cell phone data and how it can be applied to this case today.
Okay. I'm going to allow the entry of Detective Markowitz as an expert witness on the subjects identified by the prosecution. Please proceed.
Thank you, Your Honor. Let's move on and talk about the crime scene investigation that was carried out. Take the jury to the crime scene. What time did you arrive?
I arrived at 14:20 hours or 2:20 p.m.
And upon first entering Mr. Brackman's home, what did you notice?
Right at the front door, you could see Mr. Brackman's body lying there with a stab wound in his left shoulder and blood pooled around it.
Did you notice anything else about the body?
Yes, a few feet away from the body, there was also a bloodied knife.
After you noticed this bloody knife, did anything else catch your attention?
There were blood drops on the floor and cast-off marks on the walls and ceilings.
And after you noticed the body, the bloody knife, and the cast-off marks, how did you proceed?
I immediately got to work documenting these instances so that our crime scene reconstructionists could immediately view them.
What did the rest of the home look like?
It was in disarray.
What do you mean by that?
Specifically in the dining room, there was a plate shattered on the floor and a chair knocked over.
What did these scenes indicate to you?
This indicated a scuffle in the dining room between the intruder and Mr. Brackman.
And after you noticed these signs of a scuffle, what did you notice after the dining room?
Through further investigation, I also saw that there was a knife block with a large knife missing, as well as an open knife drawer.
What did you do before you left the crime scene?
I gathered the contents of Mr. Brackman's personal cell phone, which gave me the ring security footage, which are accurate copies of exhibits 10, 11, 12, and 13.
We'll look at those videos a little later, but for now, what else did you find on Mr. Brackman's phone?
A tremendous amount of texts and emails regarding something called mock trial. It appears that Mr. Brackman was the coach for a Colorado high school mock trial team. After I learned this, I reached out to get the contact info for the rest of the team.
Was this evidence important?
Absolutely. This led me to my biggest break, the interview with Alex Cifuentes.
What did you learn from this interview with Alex Cifuentes?
Cifuentes informed me of another mock trial team member, Avery Becker, who had sent texts to Cifuentes regarding getting back at Mr. Brackman after she had been kicked off of the team for vandalizing Mr. Brackman's car.
What did you do when you had learned this information?
Naturally, I tried to set up an interview with Avery Becker. However, I was immediately stopped by her lawyer and was informed that all further communications would have to go through her. Her lawyer also told me, yes, her lawyer also told me that Avery Becker had allegedly lost her phone on March 5th.
Let's transition to how you did end up obtaining that information from Avery Becker's phone. How were you able to access the phone's records?
Eventually, I got a court order.
And what pieces of evidence did you rely on for this portion of the investigation?
Cell tower records, or technically speaking, call to tail records, which I just refer to as CDRs.
Can you please explain to the jury what exactly call detail records are?
Sure. So CDRs are a record created by a cell tower which records calls and text messages, and if it was a call, how long it was lasted, and the numbers involved, as well as date and time of communication.
And with respect to the date and time, how were you able to use the call detail records in this investigation?
I was able to put together a timeline of when these events had happened.
And we were able to confirm any calls or texts to Avery Becker's phone during this time?
Yes, there were numerous texts and calls coming from another phone belonging to Taylor Perkins, yet another mock trial team member.
What did Mr. Taylor Perkins' calls and texts indicate to you?
They were all quite short or not responded to, which indicates to me that Avery Becker's phone was not being checked during this time.
Did you find anything else on Mr. Becker's phone?
Unfortunately, no. All activity on Avery Becker's phone ceased after 1320 hours on March 6th.
How were you able to compile the data gathered on Mr. Becker's phone?
I got to work putting together a diagram.
Your Honor, let the record reflect that I'm constructively showing the witness what has been previously marked as Exhibit 15 for identification purposes, as well as 16 for identification purposes. Mr. Markowitz, do you recognize Exhibit 16, 15, and 16?
Yes, these are the diagrams which I created.
What is Exhibit 15?
Exhibit 15 is a map of the cell towers which were communicating with Avery Becker's phone. And since the CDRs also keep a record of which cell tower is communicating with them, we can also create an accurate diagram of where the cell phone's location was during this time.
Is this a true and accurate copy of Exhibit 15?
Yes, it is.
And do you recognize Exhibit 16?
Yes, Exhibit 16 is another diagram that I created which highlights the route that we believe Avery Becker's phone traveled to get to Mr. Brackman's home.
Is this a true and accurate copy of Exhibit 16?
Yes, it is.
Your Honor, at this time I now move to enter Exhibits 15 and 16 into evidence.
Any objections?
No, Your Honor.
So admitted.
Detective Markowitz, what does the call detail record show on the record when someone places a phone call or a text?
It also shows the date and time of communication as well as the cell tower that it's being communicated with.
Does the record identify anything else?
Yes, it also identifies the number of the cell phone communicating with it.
How did you use Exhibit 15 to track the location of Mr. Becker's phone?
As we can see here, the first cell tower to be communicating with Avery Becker's phone is cell tower 1227-3, the cell tower closest to Mrs. Becker's home.
How did you use the location of the second cell tower to track the location of Miss Becker's phone?
Cell tower 1191-1 is the cell tower closest to Rock Creek Parkway, which we can see in Exhibit 16. Would be the most logical route for somebody to travel if they are going from Avery Becker's house to Mr. Brackman's home.
Where was the location of the third cell tower that communicated with Avery Becker's phone during this time?
The third and final cell tower to be communicating with Avery Becker's phone is cell tower 1197-1, which is the cell tower directly covering Mr. Brackman's residence.
Now, with respect to the date and time of communication, how were you able to use the call detail records to craft an accurate timeline of Miss Becker's phone during this time?
The first record picked up was at 12:47, and then at 12:55 again at cell tower 1227-3, which indicates that Avery Becker was at her home at 12:47 to 12:55. And then from 12:55 to 13:05, cell tower 1191-1 was picking up the signals, indicating that her phone was traveling along Rock Creek Parkway.
Objection, Your Honor.
What's your objection?
The witness is going into narration.
Is there a response?
I can break up my questions, Your Honor.
Yeah, go ahead and just break them up. Thank you.
What was the timeline of the second cell tower communication?
Cell tower 1191-1, the second cell tower to receive Avery Becker's phone signal, was picked up from 12:55 to 13:05, indicating that Avery Becker's phone was traveling along Rock Creek Parkway during this time.
And how can you use the timeline for the third cell tower?
Cell tower 1197-1, the third tower to pick up the signal from Avery Becker's phone, was around 13:05 to 13:17, indicating that Avery Becker's phone was picked up at the residence of Mr. Brackman during that time.
Now let's transition to your final thoughts about this case. With regards to the evidence that you relied on, what do you believe about this case?
In my expert opinion as a detective, and using all of the physical evidence gathered, the CDRs, and the interview with Alex Fuentes, it's clear to me that on March 6th of 2020, Avery Becker went to the home of Mr. Brackman with intent to break in and vandalize the home. However, upon entering the home, unexpectedly encountered Mr. Brackman, which led to a scuffle in the dining room and ultimately led to Mr. Brackman's death as he was stabbed by Avery Becker.
Thank you. No further questions at this time.
Sorry, cross-examination?
Yes, Your Honor, I do have a cross-examination.
Go ahead.
Good to see you again, Detective Markowitz. Now, you conducted the investigation for this case, isn't that right?
Yes, I was the investigator on the scene.
And you think that Ms. Becker is the best suspect for this murder, correct?
Absolutely. That's what all of the evidence points to.
But isn't it true that you did not state any specific names of other suspects in your witness statement?
That's correct, yes.
Now, let's move on, Detective Markowitz. You are familiar with Exhibits 1 and 4, correct?
Yes, I am.
And if I showed you pictures of them, you would recognize them?
Yes, I would.
Your Honor, permission to show Exhibits 1 and 4 to the court?
Yep, go ahead.
Now, Detective Markowitz, can you quickly explain what this is?
So these are pictures that I took of Mr. Brackman's body as I entered the front door.
And are these accurate copies?
Yes.
Your Honor, at this time, I move for the admission of Exhibit 1 and 4.
Any objections?
No objections, Your Honor.
All right, Exhibits 1 and 4 are admitted.
Now, Detective, I'd like you to take a look at Exhibit 1. The right hand of the body is above the victim's head, correct?
Yes, that is correct.
And now can you please turn your attention to Exhibit 4? Isn't it true that the right hand of the body is no longer above the victim's head?
That is correct, yes.
Now, Detective, when you entered Mr. Brackman's home, you noticed that the back door was open, right?
Yes, the back door is left unlocked.
But in your statement, you said that it was open.
My apologies, yes.
Yes. Now, sorry, just a second. Now I'd like you to divert your attention to Exhibit 12. Trial Tech, can you please play the exhibit for us? Or sorry, you would recognize this exhibit if I showed you, correct?
Yes.
Your Honor, permission to show the court Exhibit 12.
Apologies. Prosecution, do you have any objections to the showing of the video before it is admitted?
No objections, Your Honor.
Go ahead, counselor.
Now, Detective Markowitz, can you please explain what this is?
Yes, I believe this is Exhibit 13, a video of the ring security footage gathered through Mr. Brackman's cell phone, which shows the intruder entering through the back door.
Just making sure you think that this is Exhibit 12, not 13, correct?
This is Exhibit 13, I believe. Exhibit 10 is the video of him trying the front door. Exhibit 11 is him going around the back gate, and Exhibit 12 is the video of him going through the back door, I believe.
Yes, so this is Exhibit 12.
Oh, my apologies. I must have gotten them mixed up. Yes, that is Exhibit 12.
And is this an accurate copy of the exhibit?
Yes, it is.
Your Honor, at this time, I move for the admission of Exhibit 12.
Any objection?
No objection, Your Honor.
Exhibit 12 is admitted.
Now, Detective, isn't it true that the intruder closes the door behind them after entering the dwelling?
Yes.
Now, let's move on to Exhibits 11 and 10. You would recognize them if I showed you, correct?
Yes, I would.
Your Honor, permission to show the court Exhibits 10 and 11?
Go ahead.
Trial Tech, can you please play the exhibits if you have them available? Well, while Trial Tech is pulling them up, do you know what 10 and 11 are? Detective
Yes.
Markowitz?
As I said previously, I had the numbers mixed up, but Exhibit 10 is a video of him trying the front door, and then Exhibit 11 is him going around through the back, or the intruder.
Thank you. And
I wonder, Counselor, actually, prosecution, is there going to be any objection to the entering of these into evidence?
No, Your Honor.
Counselor, if you'd like to move to admit those, we can get those entered into evidence while your trial tech tries to get them up.
yes, Your Honor. Thank you. While Trial Tech is trying to get those up, actually, we need to.
I understand how annoying technology can be sometimes. Take your time.
Thank you, Detective Markowitz. I'm glad you understand. Well, trial, we have 2 screenshots available from the 2 videos, if we could pull those up. if the videos are not available to be pulled up on screen. Now, Detective Markowitz, the perpetrator is wearing two different shoes in these two exhibits, correct?
Yes.
Thank you, Detective Markowitz. Let's move on to the interviews you conducted in this investigation. Mr. Narayan, you may stop sharing. You interviewed Mr. Cifuentes regarding this case, correct?
That is correct, yes.
And you talked about text messages between Mr. Cifuentes and Ms. Becker with Mr. Cifuentes, correct?
Yes.
And isn't it true that Mr. Cifuentes forgot his phone at the interview?
I assume he was quite nervous, but yes, he left his phone at home for the interview.
And isn't it true that Mr. Cifuentes asked you if they could bring their phone the next day?
Yes, but I declined. I didn't see the need as I already had the screenshots.
And you told Mr. Cifuentes they could simply send you screenshots, right?
That's correct, yes.
But isn't it true that there's a possibility that those text messages could be fabricated or photoshopped?
This is really standard police work, but I suppose it is a possibility for that to happen, yes.
Thank you, Detective Markowitz. That'll be all, Your Honor.
Any redirect?
Yes, Your Honor. Detective Markowitz, why didn't you state any other names of witnesses in your witness statement you prepared for today?
Well, I follow where the evidence takes me, and in this case specifically, the evidence clearly led to Miss Avery Becker being the top suspect.
Thank you. No further questions at this time.
Are you done with the witness?
Yes, Your Honor.
Okay, and Counselor, I'm guessing no recross?
Yes, Your Honor, there's no recross.
All right, thank you, Detective Markowitz. You're excused. Prosecution, ready for your next witness.
Yes, Your Honor. The prosecution calls Ms. Kyle Kuzak to the stand.
All right, welcome, Mr. Kuzak. We'll remind you, you are under oath. Prosecution, please proceed.
Good evening. Please introduce yourself to the jury.
Good evening. My name is Kyle Kuzak.
And what is your current profession, Ms. Kuzak?
I am currently employed at the Denver Police Department as a crime scene reconstruction investigator, or CSR.
Let's first talk about your qualifications. What professional experience do you have?
I have 19 years of experience working to investigate complex crime scenes.
And could you give the jury a few examples of what complex crime scenes are?
Of course, a complex crime scene can be anything from a home invasion or robbery to domestic violence or homicides.
And Ms. Kuzak, do you have any certifications?
I do. I'm certified by the Colorado Bureau of Investigation for crime scene reconstruction.
Your Honor, I offer Ms. Kuzak as an expert in police crime scene investigation and reconstruction under Rule 702.
All right, defense, any voir dire?
Yes, Your Honor. Permission to conduct a brief voir dire of the witness.
Please proceed.
Good evening, Ms. Kuzak.
Good evening.
Now, isn't it true that you had some form of education in order to become a crime scene reconstruction investigator?
I don't state that in my statement.
I believe you do, Ms. Kuzak, but I will check. Permission to check, Your Honor?
Of course.
That would be my mistake, Ms. Kuzak. I thought you had some courses.
No problem.
Now, isn't it true that you have 19 years of experience?
I do, investigating complex crime scenes, yes.
And isn't it true that in these crime scenes, you go over and you just kind of reconstruct through a method?
Yes, I review the evidence and through a methodology reconstruct the crime scene.
Now, isn't it true that you get some of this evidence from talking to witnesses or police officers?
Yes, I review police reports and occasionally review evidence from witnesses, yes.
Thank you, Ms. Cusack. Your Honor, the defense has no objections to Ms. Cusack being entered as she is entered as a expert in the places offered.
Okay. Ms. Cusack is entered as an expert witness, and I believe prosecution, it was police crime scene investigation or reconstruction?
Police crime scene investigation and reconstruction.
And reconstruction. All right, thank you. Please proceed.
Ms. Cusack, why are you here today?
I'm here today to give my expert opinion on the conclusion of this case, as I looked over and reconstructed the crime scene of Mr. Brackman's death.
And what is your overall conclusion for this case?
My conclusion is that an intruder entered Mr. Brackman's residence through the back door, where they engaged in a struggle culminating in the death of Mr. Brackman.
Now, could you walk us through exactly what happened leading up to that?
Of course. To start, the intruder arrived on Mr. Brackman's property. We see this in the ring security videos.
And is there anything notable about that footage specifically?
Yes, it reveals what the intruder was wearing at the time of the break-in.
And why is that notable?
It reveals that they were wearing full body coverage, including a mask and gloves. The gloves in particular were important because they reveal why only the fingerprints of the victim were found at the scene of the crime.
Now, speaking of the victim, where was he at this time?
Mr. Brackman at the time was in his house, and also at this time, he would have received a cell phone notification via his ring security doorbell to alert him to the presence of the intruder.
Objection, Your Honor, outside the scope of the question.
Response?
Your Honor, I was asking an open-ended question, and as far as I am aware, there is no evidence rule that prevents witnesses from leading their attorney to a possible next question.
Any reply?
Yes, Your Honor. It was my understanding that the question was asked of where Mr. Brackman was, not what he was doing.
All right, overruled. I'm going to let it proceed.
I'll re-ask the question. Now, speaking of the victim, where was he at this time?
Mr. Brackman was inside his home, and at this point, he was also alerted via ring security notification to the intruder's presence.
So what did Mr. Brackman do after he got this notification?
Mr. Brackman went to arm himself against the intruder.
And what did he arm himself with?
He chose a Chicago cutlery chef's knife from his knife block.
Now, what did the intruder do after that first footage we captured?
We see through further footage that the intruder proceeded around the side of Mr. Brackman's house, ultimately entering the residence through the back door.
And what exhibit is that footage?
That is Exhibit 12.
Your Honor, permission for my co-counsel to constructively show the witness Exhibit 12?
Granted.
And permission for my co-counsel to constructively publish Exhibit 12 to the jury?
Yeah, and I believe Exhibit 12 has already been admitted, correct?
Yes, Your Honor.
Yeah, go ahead.
May my co-counsel play this video for the court?
Yes, of course.
Thank you. Now, how did this footage assist your reconstruction of the crime scene?
It revealed two key details. Firstly, it revealed that the intruder held no knife at the time he entered Mr. Brackman's residence. And secondly, it revealed the noise that the back door made as it slid open and shut.
And why is the noise that the back door made important?
It's important because it reveals that even in the possibility that Mr. Brackman did not receive the ring security notification, he could not have been surprised by the intruder's entrance, for he would have heard the back door open.
Now, what happened after the intruder entered?
Upon entering, the intruder came face to face with Brackman holding his kitchen knife.
And then what happened?
In my expert opinion, a struggle broke out between the two of them.
And what evidence brought you to that conclusion?
There were scuff marks by the back door where the intruder entered, as well as a broken plate at the kitchen table.
And could you elaborate on that a little bit further?
Of course, the broken plate at the kitchen table was roughly 5 feet away from the back door where the scuff marks were located, so this indicates that the struggle moved from the back door to the kitchen table.
And apologies, Ms. Guzak. What happened as the struggle moved to the table?
At this point, the intruder stole the knife from Mr. Brackman.
And what happened after the intruder got a hold of the knife?
Around this time, Mr. Brackman ended up pinning the intruder's arms to their sides in a sort of bear hug-like hold.
How did the intruder react to being pinned like that?
They reached up around the side of Mr. Brackman and ended up.
Speculation.
Sorry, what was the objection?
Speculation, Your Honor.
All right. Response?
Your Honor, this is not speculation, as I am simply asking the witness to testify to the best of her knowledge. She is a crime scene reconstructionist, so reconstructing and putting together exactly how a crime would have gone down is in her expert field and her job purview. This testimony is a logical conclusion from the evidence that she has already spoke of.
Reply?
Yes, Your Honor. Ms. Kuzak previously stated she bases all of her conclusions off the evidence, and the prosecution has yet to show any evidence that the intruder was pinned down in a bear hug.
I'm going to overrule the objection, but I would caution prosecution that this testimony is getting pretty close to more bare guessing than simply testimony based on the evidence. Go ahead.
Yes, Your Honor. Now, Ms. Kuzak, do you have a reason for why you believe the intruder was pinned like that?
Yes, the autopsy report reveals the exact location of the wound on Mr. Brackman, and in order for that positioning of the wound to have taken place, the bear hug-like hold would be the most probable conclusion for why that happened.
Now, where were the intruder and Mr. Brackman when this stabbing happened?
Unfortunately, there's no way to know for certain, for a wound of this nature would not create any large blood splatter or physical evidence of that sort. However, there was a trail of blood droplets leading from the kitchen table to the front door.
And is there evidence of that blood trail here in court today?
Apparently, it isn't. Apparently, at some point during the investigation, the file was corrupted.
And how did that affect your ability to review that evidence?
It didn't. This file corruption took place at some point after my review.
All right, so what did happen after the intruder stabbed Mr. Brackman?
We can see through footage taken by the ring security camera that the intruder exited the house through the front door.
And what happened to Mr. Brackman?
When Mr. Brackman was by the front door, he pulled the knife out of his own back.
And Ms. Kuzak, what happened after this knife was removed from Mr. Brackman's back?
He started bleeding at a quite accelerated rate and died almost instantly.
Thank you. Your Honor, no further questions at this time.
Cross-examination?
Yes, Your Honor. Good to see you again, Zach. Now, I would like to talk about how you reconstructed this case. Isn't it true that to do this, you make a witness tracking sheet and a flowchart?
I do, yes.
Would you be able to recognize them if I were to show them to you again?
Yes, I would.
Your Honor, permission for our trial tech to put up Exhibit 17.
Yeah, go ahead.
Mr. Narayan, this is Exhibits 1 and 4, not Exhibit 17. Thank you. Now, isn't it true that this is your witness tracking sheet?
Yes, it is.
Isn't it true that this is a fair and accurate copy of that sheet?
It is, yes.
Mr. Narayan, if we could turn to the flowchart, please. While our trial tech is in the process of pulling that up, I would like to enter at least the witness tracking sheet, so the first page of Exhibit 17, as it has been authenticated and identified by the witness.
Any objections?
Yes, Your Honor. The prosecution objects as this is hearsay within hearsay.
Response?
Your Honor, the witness tracking sheet is a regularly conducted business order, so therefore it falls under an exception to hearsay.
I'm wondering, could you lay a little bit more foundation on the business record exception?
Of course, Your Honor. Ms. Cusack, do you conduct every crime scene reconstruction in the same way?
I do.
And do you create a witness tracking sheet every time?
Yes, to further keep track of evidence.
Thank you, Your Honor, or thank you, Ms. Cusack. Your Honor, is this enough foundation or should I lay more?
I'm wondering, Ms. Cusack, are you the custodian of these records?
I am.
I'm going to overrule the objection and we're going to admit Exhibit 17.
Now, Ms. Cusack, I would like to direct your attention to the very top of the flowchart before us. Isn't it true that this information is derived from an interview with Detective Markowitz?
Yes, as well as evidence that I reviewed and yes.
So the vast majority of this evidence comes from an interview with the person accusing, Ms. Becker, correct?
As well as evidence that I reviewed, yes.
Thank you, Ms. Cusack. I would like to direct your attention back to the witness tracking sheet. Now, I would like to turn your attention to the third witness on this sheet, Mr. Cifuentes. Isn't it true that they are named as the second suspect in this crime?
They are, yes.
Thank you, Ms. Cusack. Mr. Narayan, you can take this down. Now, Ms. Cusack, I would like to direct your attention to Exhibits 1 and 4. Mr. Narayan, if you would please bring them up. Mr. Narayan, if you, thank you. If you can check out the Exhibit 1 on the left side of the screen. Isn't it true that the victim's right hand is above his head?
Objection, Your Honor. Prejudicial over probative.
Response?
Your Honor, these are both exhibits and a line of questioning that was done with Detective Markowitz with no objections done there. And this amount of evidence goes to the crime scene reconstruction and the overall investigation in this case and how reliable and credible it is.
Reply?
Yes, Your Honor. This is a picture of a graphic scene that is only being used to prove something slightly relevant. That is the position of Mr. Blackman's hand. Therefore, the prejudicial value of this is strongly outweighing any probative.
Okay, I'm going to overrule, and I would note that this is the prosecution that entered this into evidence. Once you open that door, if you have a photograph out there, the other side can use it for whatever they'd like. Please proceed.
Ms. Cusack, I would like to direct your attention to Exhibit 4, the picture on the right side of the screen. Isn't it true that the victim's right hand is no longer in the same position as Exhibit 1?
It seems like it's not, no.
Thank you, Ms. Cusack. Now, as part of your conclusion, you concluded that Mr. Brockman pulled the knife out of his own back, correct?
Correct.
Now, would you recognize an image of the murder weapon if I were to show it to you?
I would, yes.
Your Honor, permission to constructively show Exhibit 5 to the witness.
Go ahead.
Now, Ms. Cusack, is this an accurate representation of the murder weapon?
It is, yes.
And this is a picture of that murder weapon, correct?
Correct.
Your Honor, pursuant to Rule 901, the witness has authenticated and identified the exhibit. Permission to move it into evidence?
Any objection?
Yes, Your Honor. Lack of foundation, as Ms. Cusack is not a custodian of this exhibit, and the whoever has took this photo is not in court to testify about it today.
Reply.
Your Honor, it is my understanding that these images came from Detective Markowitz.
Okay, we don't have Detective Markowitz to testify to that, though. Ms. Cusack, was this photograph in the police file?
I did review it, yes.
Okay, I'm going to admit Exhibit 5.
Now, Ms. Cusack, I would like to direct your attention to the handle of the knife. Isn't it true that there's blood on this?
There is, yes.
Now, I'd like to turn back to Exhibits 1 and 4. If you look at the victim's hands, isn't it true that we cannot see any blood directly below his hands that would have dripped from them?
We cannot also see the underside of the victim's hand, so it is impossible to tell.
Thank you, Ms. Cusack. But is it true that we can't see any, from the parts of the floor that we can see, isn't it true that there's no blood underneath the victim's hands?
I guess not. However, we can't
Thank
see
you, Ms.
them.
Cusack. Now, I would like to talk about, thank you, Ms. Cusack. The defense has no further questions.
Redirect?
A brief redirect, Your Honor. Ms. Cusack, you were just asked a few questions regarding the lack of blood on Mr. Brackman's hand. Could you walk us through exactly what would have happened when Mr. Brackman removed that knife from his back?
Yes, due to the nature of the stab wound, when it was removed, a blood splatter would have what did cascade up the ceiling and wall, which could have potentially splattered the knife handle.
Thank you. Your Honor, no further questions.
All right. Any recross?
No, Your Honor.
Prosecution, are you done with Ms. Cusack?
Yes, Your Honor.
All right, Ms. Cusack, thank you. You are excused. Next witness.
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand.
All right, good evening, Mr. Cifuentes. I remind you, you are under oath from the beginning of these proceedings. Prosecution, please proceed.
Yes, Your Honor. Good evening. Would you please introduce yourself to the jury?
Hi, my name is Alex Cifuentes.
Why are you here today, Mr. Cifuentes?
I was a junior at CHS when my mock trial coach, Mackenzie Brackman, died.
Let's talk about mock trial. What is mock trial?
Mock trial is an awesome club. We spend most of the year preparing these fake examinations. We spend put a lot of work into these fake examinations, and then we present them at fake court cases. It's so much fun.
What does mock trial have to do with today's case?
Mr. Brackman was my mock trial coach, and Avery and I were on the CHS mock trial team.
Let's talk about the defendant, Miss Becker. How do you know Miss Becker?
Avery and I were friends, and I saw her all the time until she got kicked off the team.
Why was Miss Becker kicked off the team?
She wrote Worst Attorney Award on Mr. Brackman's car in permanent marker.
Why did she do that?
Objection.
Avery and Mr. Brackman had been
Sorry,
off.
Mr. Cifuentes, hold on one second. What's the objection?
A speculation, Your Honor.
Response?
Yes, Your Honor. This is not speculation, as Mr. Cifuentes was there at the time that this happened and can testify to this based on his reasonably based perception.
Reply.
Your Honor, Mr. Cifuentes would have no idea for the real reason why Miss Becker would have vandalized Mr. Brackman's Porsche, so hence he cannot testify to it.
All right, Mr. Cifuentes, I'm going to overrule the objection. You can testify to the best of your knowledge. Go ahead.
I'll re-ask the question.
Thank you.
Why did Miss Becker draw on Mr. Brackman's car?
Avery and Mr. Brackman had been at odds for a while.
Based on your perception, why were they at odds?
Avery was always coming late to practices. She never prepared for examinations. She would come to tournaments and just wing it. It really frustrated Mr. Brackman. Eventually it got so bad, Mr. Brackman demoted Avery to the B team.
What happened next?
Well, Taylor Perkins quit and Avery got back onto the A team.
Then what happened?
Avery and Mr. Brackman were not any friendlier towards each other. Avery still came late to practices, still didn't prepare, and Mr. Brackman still told her off for it.
Did anything happen after that?
Well, Avery vandalized Mr. Brackman's car and got kicked off the team.
Did you have any interactions with Miss Becker after she was kicked off the team?
I did, yes. I saw her the afternoon before the murder.
Let's talk about that afternoon. What happened the afternoon before Mr. Brackman's death?
Well, after Avery tried to come to a mock trial practice and was denied admittance, I saw her and Taylor Perkins at this fast food place called the Fry Shack. All the mock trial kids went there. We had this big, long talk about moving forward. That's probably when she assumes I stole her phone.
Why would she assume you stole her phone?
I learned that she thinks that I stole her phone and gave it to some kid named Blair Rollins.
Who is Blair Rollins?
Blair is some kid who went to CHS with me and Avery.
Was this the only interaction you had with Miss Becker after she was kicked off the team?
No, she texted me after she was kicked off the team.
Let's talk about those texts. Your Honor, may I constructively show the witness Exhibit 14?
Go ahead.
Co-counsel, would you please pull up Exhibit 14? Thank you. Mr. Cifuentes, do you recognize Exhibit 14?
I do, yes.
What is Exhibit 14?
This is a text conversation between me and Avery.
Is this a complete and accurate copy of Exhibit 14?
It is, yes.
Your Honor, at this time, I move to enter Exhibit 14 into evidence.
Any objection?
Yes, Your Honor. I object on the grounds of hearsay as this document is unauthenticated.
Response?
Your Honor, this is not hearsay as it is a statement of opposing party under Rule 801 D2.
I agree. I'm going to admit Exhibit 14.
Thank you, Your Honor. Mr. Cifuentes, did Miss Becker tell you anything of note in this conversation you had?
Yes. She asked me if I could talk to Mr. Brackman to allow her to get back on the team.
So what did you do?
I went and talked to Mr. Brackman, and he was having none of it. So I told her that Mr. Brackman didn't want her back on the team.
And if you'll please direct your attention to the second page of this exhibit. Is there anything else that Miss Becker said to you that you would like to talk about?
Yeah, she got angry about not being allowed back on the team. She said if Mr. Brackman was upset about his car, he would be really upset what she was going to do to his house.
Thank you, Your Honor. No further questions.
All right. Cross?
Yes, Your Honor. Good evening, Mr. Cifuentes.
Good evening.
You are on the Colorado High School mock trial team, is this correct?
I was, yes.
And you and Avery competed on the same team?
We did, yes.
You took mock trial very seriously. Is this also correct?
I loved mock trial. It was a big part of my life. So yes, I took it very seriously.
Isn't it true that you claim to be friends with Miss Becker?
I do, yes. I like to think we were friends.
Yes. Do you also think that Miss Becker was constantly late to practice and never came prepared?
She definitely was, yes.
And didn't you ask Mr. Beckman multiple times why he put up with Avery?
He seemed annoyed by her, so I did ask him on occasion, yes.
Now, Miss Becker won 2 awards at the regional competition. Did you say that this felt like a slap in the face?
Yes, I did.
And isn't it true that you thought Miss Becker only won awards based off of her good looks?
She does have skill, but sometimes all juries are looking for is performance and good looks. So I think on this occasion, that was the truth. That was what happened.
Okay, thank you. I'd now like to move on to relationship with Blair Rollins. You went to school with Mr. Rollins, is this correct?
Yes.
And you claim to not have a meaningful relationship with Mr. Rollins. Is this also correct?
I'm fairly sure I never even had a class with the guy, let alone a meaningful relationship of any kind.
But isn't it also true that you greet Blair Rollins in the hallway?
It's a common courtesy.
In the future, Mr. Cifuentes, I'd like you to keep your answers to yes or no.
Well, in this case, it was yes.
Okay, well, thank you. I'd now like to move on to the text messages. Did Miss Becker text you after the incident, asking you to talk to Mr. Brackman for her?
She did, yes.
And in these texts, did Miss Becker threaten to break into Mr. Brackman's house?
She did, yes.
And you didn't tell anyone about Mr. Becker's plan, did you?
I honestly didn't really know how to tell. I didn't know what to do with the texts.
You didn't tell any police officers?
Again, I didn't really know what to do with them. I didn't know how to admit them. I didn't know what to do with the texts I had.
Yes. Didn't you forget to take your phone to the police station with you when you were being interviewed by Detective Markowitz?
I did. It was a very flustering time for me. I always having to plug my phone in. I plugged my phone in and I just forgot it as we went out the door. So
Mr. Cifuentes, again, yes or no?
Yes.
And rather than bringing in the actual phone, you instead sent the Exhibit 15 screenshots to Detective Markowitz. Is this also correct?
I offered to go grab my phone, but he said screenshots will be perfect.
Mr.
So
Cifuentes,
yes,
again.
yes, I sent in screenshots.
And Mr. Cifuentes, did you also get a new phone 3 months ago?
My phone was super old. The battery was old. I needed a new phone.
Again, yes or no?
And again, yes.
Okay, thank you, Your Honor. That's all the questions I have.
Redirect?
Yes, Your Honor. Mr. Cifuentes, why didn't you tell anyone about these texts until the police contacted you?
I didn't really know what to do with the texts. I didn't know how to send them to the police. And when the police called me for an interview, it felt like an amazing time to give them the texts.
And why did you forget your phone at this interview?
My phone was so old and the battery was so old. I always had to plug it in. And my battery ran out before the interview, so I plugged it in and I got called to go to the interview. It just completely slipped my mind.
Thank you, Your Honor. No further questions.
Right. Any recross?
No, Your Honor.
All right. Thank you, Mr. Cifuentes. You are excused. Prosecution, do you have any other witnesses?
The prosecution rests, Your Honor.
Okay. I think I know the answer to this question, but before we begin with the defense in chief, any halftime motions?
None from the prosecution, Your Honor.
Okay. Would the defense have, and I'm guessing the defense has no halftime motion unless you'd like to make one now.
That is correct, Your Honor.
All right, defense, go ahead and present your defense in chief.
Your Honor, the defense would now like to call Avery Becker to the stand. Good evening, Ms. Becker. Would you please state your name for the court?
Yeah, hi, Avery Becker.
Why are you here today, Ms. Becker?
I'm here because I'm being falsely accused of the murder of my coach, Coach Brockman, my mock trial coach.
How long were you in mock trial?
4 years, all of high school.
And did you enjoy being in mock trial?
I loved it. It was one of my favorite things to do.
What was your relationship like with your teammates?
I got the feeling that they got a little irritated when I came to practice unprepared or less prepared than they did.
What was your relationship like with your coach, Mr. Brackman?
It was kind of rocky. We disagreed about some things, and he didn't really like my work ethic. I really wish I had the time to make it up with him, though.
Do you think this is why your relationship was so strained?
Yeah.
How did Mr. Brackman act towards your teammates?
He acted like a normal coach would. He gave good criticism. He coached them well. He was a good mentor. But yeah.
How did Mr. Brackman act towards you?
Well, he had a grudge. It seemed like he had a grudge, and I felt like I could never really please him, no matter how hard I tried.
Earlier today, we've heard about an incident with a Porsche. Will you please tell us about that from your point of view?
Yeah. Where would you like me to start?
At the beginning of that practice, please.
Okay. Well, it was the Tuesday night. It was practice after regional. It was on Tuesday night.
What happened during that practice?
I was going to write on the whiteboard. I was going to write about all the things that we did well during the tournament. But then Mr. Brockman stopped me just before I was about to write on the whiteboard.
And what happened?
Well, he interrupted me, and he started like yelling at me and criticizing me and telling me that I didn't deserve the win or my award.
Response?
Your Honor, under Rule 801, this does not even fall under the definition of hearsay, as we're not offering it for the truth of the matter asserted. We are offering it simply to show the relationship between Ms. Becker and Mr. Brackman.
Reply?
Your Honor, I believe they are using this for the truth of the matter asserted, and it is being able to describe their relationship prior to when Avery Becker vandalized the car.
I'm going to sustain the objection. I do think this is hearsay. Proceed.
Ms. Becker, what did you do after Mr. Brackman was yelling at you?
Well, I went outside to take a breather, and I noticed that I had the marker that I was about to write on the board with, and still in my hand.
And what happened after this?
This is the worst mistake of my life, but when I looked up and right in front of me was the Porsche, his Porsche, and I wrote on it.
Ms. Becker, how did Mr. Brackman react when he saw the Porsche?
Well, he talked about that thing like it was his most prized possession. And he was very mad, and he eventually kicked me off of A team, sorry.
Ms. Becker, before we move on, I'd like to ask, are you okay?
Yeah, sorry, this is just really, really hard.
Yeah, I understand that, Ms. Becker. In your opinion, did you think it was a did you think it was a permanent marker when you wrote Mr. Brackman's Porsche?
No, never. I was just trying to. It was a stupid act when I wasn't even thinking about my actions.
Now, Ms. Becker, I'd like you to tell us what happened after all of this.
Well, I was a little mad. I was also really upset with myself, and so I went home and I told my mom about it, and she advised that I go to Mr. Brockman's office the next day and apologize in person.
And what happened when you were trying to apologize?
Well, I went to his office, and but they wouldn't let me in to apologize because I got told that he didn't want to see me.
And so what did you do?
Well, I texted him my apology after that. I even offered to get a summer job to help repaint his car.
What did you do after you texted him?
I went to the fry shack with Taylor, and there I saw Alex and the rest of the mock trial team.
I'd now like to move on to discuss your relationship with Mr. Cifuentes. Can you tell us about your relationship with Mr. Cifuentes?
Yeah. He and I were honestly just acquaintances. I mean, I saw him at mock trial practice, but really that was it. And I mean, we weren't the closest of friends, despite what I heard him say in his testimony.
So you didn't hang out with Mr. Cifuentes?
No, not really.
Well then, who did you see Mr. Cifuentes hanging out with if it wasn't you?
Well, I saw him hanging out with Blair Rollins. Yeah.
Did Mr. Rollins have any connections to mock trial other than Mr. Cifuentes?
Well, from what I understand, Blair's father was a client of Brockman's, and he didn't succeed in the trial, and Blair's father ended up going to jail, and so I think he might have a little bit of a grudge against Brockman.
Objection, speculation.
Response?
Your Honor, the witness was simply stating what she observed about Mr. Rollins.
Reply?
Your Honor, under Rule 602, there is a need for personal knowledge, and I believe that Ms. Becker cannot testify as to whether the thoughts of Blair Rollins were that he had a grudge against anyone or did not have a grudge against anyone.
All right, I'm going to overrule for now, but I would caution counsel to be careful about leading your witness into too much guessing about other people's motivations.
Yes, Your Honor. Ms. Becker, I'd now like to move on to the investigation. Did your lawyer show you the prosecution's case evidence?
Yeah, they showed me the ring. They showed me the ring videos. Yeah.
And is the figure in these videos you, as the prosecution alleges?
No, it's not me.
The prosecution alleges that the person in the video is about your size. Do you agree with this assertion?
Yeah, but so are a lot of people. Honestly, my age, so are a lot of people.
Did you hear Detective Markowitz's testimony regarding the cell phone records associated with your phone?
Yeah, I heard it. I heard it here when he was talking about it.
Where was your phone at the time of the murder?
I don't know. I lost it.
When did you realize your phone was missing?
I realized it early on March 6th.
Did you go and search for your phone?
Yeah, me and Taylor Perkins, my best friend, we went and searched for my phone.
And did you find your phone?
No, despite looking at all the places that I was previous days before, we never found my phone.
Where were you looking for your phone?
The fry shack and the mall. We were trying to retrace my steps.
And in the course of all of this, were you ever near Mr. Brackman's house?
No, I don't even know where his house is even located. I couldn't even point it out to you even if I tried.
Thank you, Ms. Becker. Your Honor, that's all the questions I have.
I believe you're muted, Your Honor.
I am. I apologize. I have a distraction that keeps coming into the room. Cross?
Yes, Your Honor. Good evening, Ms. Becker. I'm going to begin by asking you a few questions about your relationship with Mackenzie Brackman. Mr. Brackman was your mock trial coach?
Yeah, he was.
However, you and him never really got along.
We had our disagreements.
This is because he believed that you were lazy?
In his terms, yeah.
Because while he wanted you to put more time into your mock trial work and prepare your materials, you say you have an ability to come up with things on the fly. Is that correct?
Yeah, is there anything wrong with having a little bit of a talent for stuff like that?
Is that a yes?
That's a yes.
And this led to you and Mr. Brackman arguing at almost every mock trial practice?
Yeah.
And along with his title of mock trial coach, Mr. Brackman is also a local defense attorney.
Yeah, I've heard that, yeah.
However, it is your opinion that Mr. Brackman wouldn't know a good cross-examination if it hit him over the head. Is that correct?
Yeah. I said that in a moment where I wasn't thinking clearly.
Was that a yes? You did say that?
Yeah.
Is that a yes? I need a verbal yes or no from you, Ms. Becker.
Sorry. Yeah.
I would now like to talk about the vandalism incident with Mr. Brackman's Porsche. Before the regional mock trial tournament, you were bumped down from the A team to the B team?
Yeah.
However, your friend Taylor Perkins offered you up his spot, correct?
He knew how much it meant to me, and he was willing to make that sacrifice.
Is that a yes? He did offer you up his spot?
I thought I already answered that.
I just need a verbal yes or no from you to confirm.
Okay. Yes.
And at regionals, you ended up winning Best Attorney Award and Best Closer, correct?
Yeah.
Your Honor.
What's the objection?
Your Honor, I don't see how this is relevant to the case.
Response?
Your Honor, my line of questioning will clarify how this is relevant, and as I'm explaining the relationship between Mr. Brackman and Ms. Becker.
Reply?
Your Honor, whether or not Ms. Becker did well at the regional tournament does not affect her relationship with Mr. Brackman.
I'm going to overrule the objection for now, but Counselor, do try to pull it back into the realm of this case.
Yes, Your Honor. And after you won these awards, Mr. Becker still thought you should have put more time in and followed the scripts. Mr. Brackman, sorry, thought you should have put more time in and followed the scripts, correct?
Yeah, but I thought I had a better. I thought I had a better argument that fit the case better, where the case was going.
This may be true. However, Mr. Brackman did think that you should have put more time in and followed the scripts, correct?
I don't know what he thought, but that's what he acted like.
Is it your testimony today that he did not think you should have put more time in?
No, he did.
Is that a yes?
Yes.
Thank you. And this made you very angry that he felt this way. Is that right?
Yeah.
It made you so angry that you called Mr. Brackman the worst coach in the state?
Again, I said that out of place of not thinking clearly.
It also made you so angry that across the hood of Mr. Brackman's vintage Porsche, you wrote Worst Attorney Award with a Sharpie?
I didn't realize that it was, I didn't realize that it was a little, I didn't know that it was a permanent marker at that time.
Ms. Becker, I'm not asking you if you knew it was a permanent marker. I'm just asking if you did write that across Mr. Brackman's car. Did you not?
I said that already in my direct.
In court today, I need you to give a verbal yes or no as to whether or not you did do that.
Sorry, yes.
Let's talk about the aftermath of that vandalism incident with Mr. Brackman's Porsche. When Mr. Brackman saw what you had done to his car, he kicked you off the team, correct?
Yeah.
This made you even madder.
Yeah.
So you decided to go home and tell your mother that you had gotten kicked off the mock trial team for no good reason, is that correct?
Well, I didn't see the reason at the time, so yeah.
So you did not tell your mother that you vandalized Mr. Brackman's Porsche, did you?
I was ashamed of what I did, so not right then.
You told her that Mr. Brockman had followed you out of practice, gotten angry, and just kicked you off the team out of nowhere, correct?
Again, I said I was ashamed, so yes.
You also told your mother that you would get back at Mr. Brockman if it was the last thing you did. Is that correct?
I used an exaggeration of words, but yes, I said that.
I would now like to talk about the afternoon of March 6th. You never attended school this day?
No, we sort of had a free period, first period, so me and Taylor decided to skip school to look for my phone.
And Taylor Perkins was the only person you were with this whole day, correct?
Yeah, nobody else, just me and him.
So to your knowledge, no one else can account for your whereabouts on this day?
No.
And is it true that you only noticed your phone was missing the day after March 5th on March 6th?
Can you repeat the question? It was a little confusing the way you asked it.
Yes, I can reread the question. After you were with Taylor Perkins on March 5th with your phone, you only noticed the phone was missing the morning after on March 6th, correct?
Yeah. The morning of March 6th, yeah.
I would now like to discuss the text with Alex Apuentes. You're aware that Alex Apuentes claims you texted him asking for help to get back on the mock trial team?
That is correct.
You're also aware that within these texts, Alex Apuentes claims you divulged your plan to trash Mr. Brockman's home.
Can you repeat the question, please?
Yes, you're also aware that within these text messages, Alex Apuentes claims that you divulged your plan to trash Mr. Brockman's home.
Yeah, that's what the text message appear to say.
Finally, you also say that the person pictured in the Ring security camera footage matches your own height and build, correct?
A lot of people match my own height and build, and so does Blair Rowland's.
But you do say that it matches your own height and build. Is that a yes?
That was a yes. That was sort of clear, yes.
No further questions at this time.
Redirect?
Yes, Your Honor. Ms. Becker, would you please explain how you feel about what you did to Mr. Brockman's Porsche?
Oh, I feel so bad. This is the worst thing that I've done in my entire life, and I was so stupid to even think about doing it. I just really miss him, and I'm really sorry for what I did and for what I did to his Porsche, and I would never ever think about killing him.
Your Honor, that's all the questions I have. Thank you.
All right, any recross?
No recross, Your Honor.
All right, Ms. Becker, you are excused. And defense, next witness.
Yes, Your Honor. The defense would like to call Taylor Perkins to the stand. Before we begin,
yes,
your permission to conduct or to ask for a brief time check.
Yeah, of course. Where are we with time?
You have 16 minutes and 1 second left for direct.
Thank you. Good evening, Mr. Perkins.
Good evening.
Would you please state your name for the court?
Taylor Perkins.
And why are you here today, Mr. Perkins?
I'm here today because my best friend, Avery Becker, has been wrongfully accused of murder.
Now, do you know Miss Becker?
Of course I do. She's my best friend.
And did you know Mr. Brockman?
Yes, I did.
How did you know him?
Mr. Brockman, or Coach Brockman, was the coach of our mock trial team at CHS.
What was Mr. Brockman like?
He was very serious, hot-headed, very fast to anger, especially when it came to Avery. Those two always seemed to be fighting.
Why were they fighting, Mr. Perkins?
Well, it was a variety of reasons. I can't lie. They both were very high-tempered, and Avery made some mistakes that she really regretted when frustrated.
Now, Mr. Perkins, to your knowledge, did Mr. Brockman act like this with any of the other team members?
I can't really say because I really only paid attention to Avery and myself.
Now, did you and Ms. Becker know any of the other members on the Colorado High School mock trial team?
Not really. We didn't know many of the members, except for, I suppose, Alex Cifuentes, who acted like a rival of Avery's. He and I were never particularly close.
Now, Mr. Perkins, I would like to move on to the day in question. On March 6, 2020, where were you?
It's a bit of a long story, but I was at the mall and the Fry Shack.
And who are you with, Mr. Perkins?
I was at Avery. She'd lost her phone the day prior, so we went looking for it.
And Mr. Perkins, was there any time during this day that you were not with Miss Becker?
No. After she picked me up in the morning, we were exclusively together for the whole day.
Now, Mr. Perkins, during this time, were you and Miss Becker anywhere near Mr. Brockman's house?
To be honest, I'm not entirely sure where Mr. Brockman's house is, but as I said, we were exclusively at the mall and the Fry Shack.
Now, in this trial, another student, Blair Rollins, has been brought up. I would like to talk a little bit more about him. Were you close with Mr. Blair Rollins?
No, in fact, I distanced myself from Blair Rollins.
Why did you distance yourself from him?
Frankly, he terrified me. He just has that sort of standing reputation to be either a hitman or a serial killer.
And Mr. Perkins, to your knowledge, was he at school that day?
This is question calls for speculation.
Response?
Your Honor, this is not speculation, as Mr. Perkins would have talked with the defense lawyers, including and gotten the information they've had from the prosecution side, as well as our expert, who has made sure that Blair's whereabouts during this time.
Reply?
Yes, Your Honor. As Mr. Perkins testifies that he was not in school that day, he has no personal knowledge of whether or not this Blair Rollins was in school that day. And furthermore, if the argument is raised that he was told this by his lawyers, I would like to bring up a hearsay objection as well.
Yeah, I'm going to sustain the objection based on, not on the hearsay, but based on the speculation. Mr. Perkins, if you were not in school that day, you can't testify as to whether somebody was actually there. Proceed.
Move to strike the witness's response.
Granted.
Mr. Perkins, on March 6, 2020, were you at the mall?
Yes.
And Mr. Perkins, who were you with?
I was with Avery Becker, my best friend.
Thank you, Mr. Perkins. The defense has no further questions at this time.
All right. Cross?
Yes, Your Honor. Good evening, Mr. Perkins. I'd like to start by going over your personal history with the defendant a bit more. Now, on cross-examination, you testified that the two of you are best friends, correct?
I don't believe I've been cross-examined yet.
You testified on direct examination that you and the defendant are best friends. Isn't that right?
Yeah. Avery and I have been best friends ever since she introduced me to mock trial.
In fact, you only did mock trial because the defendant did it. Isn't that true?
Objection, Your Honor. Relevance?
Sorry, what was the objection?
Relevance, Your Honor.
All right, response?
Your Honor, this testimony will be going to show the witness's bias regarding Avery Becker in this case.
Reply?
Yes, Your Honor. The reasons as to why Mr. Perkins joined mock trial does not bear any relevance to his friendship or relationship with the defendant.
Your Honor, may I respond?
Sure.
May I make an offer of proof?
Yes.
If allowed to testify, Mr. Perkins will testify that the only reason he did mock trial was because the defendant did it. Therefore, it is very relevant to his relationship with the defendant.
But how is that relevant as to whether the defendant committed this murder or not?
Your Honor, it is relevant in that it will show that there is a possibility that Mr. Parkins may not be entirely truthful with his testimony here today.
Okay.
Response, Your Honor?
Yeah, please.
Your Honor, whether or not Mr. Perkins joined a team to order to be with somebody does not mean that they will lie to cover up for them for murder. So the cause of him joining the team doesn't bear any relevance to whether or not Avery committed this murder.
I'm going to sustain the objection. I think the jury can assign their own weight to Mr. Taylor's evidence based on what they've heard so far. Please proceed.
Yes, Your Honor. Now, Mr. Parkins, in your opinion, you and the defendant made mock trial great. Isn't that correct?
Yeah, that is my opinion. Avery was definitely the star of the show, but I wasn't too bad myself.
And you'd agree with me that the defendant can be rash. Isn't that true?
Yeah, definitely. Avery has a tendency to be rash.
And she has an inflated ego too. Isn't that correct?
Objection, Your Honor. Improper character evidence.
Response?
Your Honor, this is not improper character evidence, as I am asking Mr. Parkins for his opinion regarding a person who he knows very well, as he has testified that she is his best friend. Furthermore, this is going to testify, this is going to further, I apologize, I'm just not going to continue that line of speaking.
That's all right. Reply to what Counselor just said. Do you have a reply, Ms. Cornelio?
Your Honor, I stand by my objection.
Okay. I'm wondering, Ms. Hirsch, are you are you going down this line trying to establish a particular character trait of the defendant for a particular purpose, or to show that she acted a particular way on a particular occasion?
Your Honor, I am going down this line to prove a, I suppose it would be to prove a trait, and that she has a repeated history of these actions. It is not to directly implicate her in any future actions.
Okay. I'm going to allow it for now. I'll overrule the objection, but I'm going to caution witness that when you get into character traits or character evidence, things can tend to get very sticky. Please proceed.
Yes, Your Honor. Mr. Parkins, I'm going to re-ask the question. Now, you'd say that the defendant had an inflated ego. Isn't that correct?
Yeah, sometimes Avery definitely had an inflated ego.
And even on direct examination, you said that she was high-tempered. Isn't that true?
Yeah, as I said, she had a tendency to be rash and irrational.
Now, I'd like to turn your attention to your time on the mock trial team. Now, during this time, Mr. Brackman always seemed to be giving the defendant a hard time. Isn't that true?
Yeah.
And you found this feud to be funny.
Yes, I did. I thought it was funny because they just got off on the wrong foot.
It did bother the defendant, didn't it?
Objection, Your Honor. Speculation.
Response?
Your Honor, I am asking Mr. Parkins to testify to the best of his knowledge, as he was there at the time to personally witness this, and he is friends with the defendant. He could, from his perspective, he is qualified to give an opinion on whether or not this bothered the defendant.
Reply.
I stand by my objection, Your Honor.
Overruled.
Mr. Parkins, I'm going to re-ask the question. This feud of theirs did bother the defendant, isn't that true?
Yeah, from my observations, it did bother her.
And it bothered her enough that she'd play some pranks on Mr. Brackman.
Yes, occasionally she did.
let's talk about what happened after the defendant got kicked off the team. Now, the defendant got kicked off the team for vandalizing Mr. Blackman's call. Isn't that true?
Yes, that is true.
And after the defendant got kicked off the team, you'd say that she tried everything to get back on it, correct?
Well, everything within reasonable means. We spoke to a lot of the members on the team about.
In fact, not only did you speak to them, but she texted everyone trying to see if she could get back on, correct?
Objection, Your Honor, speculation.
Response?
Your Honor, this is not speculation, as again, Mr. Perkins testified that he was involved in this, and therefore he would know whether or not Miss Beckel had done this course of action or not.
Reply.
Your Honor, Mr. Perkins said that he was talking with the mock trial students with Avery. What she did or who she texted is not something he would have been aware of.
Sustained. Go ahead.
Yes, Your Honor. Mr. Perkins, you'd agree with me that you and the defendant discussed how she could get back on the team, correct?
Yeah, my friend was sad, so naturally I wanted to speak to her to make her happy again. That's why we even play video games from time to time when she's frustrated, because they help her get over her anger.
Finally, I'd like to talk about what happened in the days leading up to the murder. Now, you claim that on the day of the murder, March 6th, you were looking for the defendant's phone, correct?
Yes, that is correct.
And this is the phone that the defendant supposedly lost the day before.
That is also correct.
Now, the defendant's phone was never out of her reach, isn't that true?
Yeah, she carried around quite a lot. It was like her third kidney almost.
Yet, when the defendant's phone went missing, she didn't realize it was missing until the next day.
Objection, Your Honor, speculation.
Response?
Your Honor, this is not speculation, as Mr. Perkins was with the defendant the next day, and they went looking for her phone, so he would know when she did realize this phone was missing.
Reply?
Your Honor, Mr. Perkins may have been with her the next day, but that does not mean he can testify to when she realized it was missing. And if she were to have realized it missing the night before or time they were not together, she would not have a way to contact Mr. Perkins to inform him it was gone.
Your Honor,
actually, hold on, Counselor. I'm gonna overrule the objection. I think that a lot of this is just kind of going over what Mr. Perkins has already testified on. Proceed.
But when the defendant's phone went missing, she didn't realize that until the next day, correct?
Yeah,
Now, the defendant had an Apple phone, correct?
Yes, that is correct.
And you could have used the Find My Phone function to find it. Isn't that true?
Well, I have an Android, so I'm not very well versed in the ways of Apple, and Avery was quite distraught looking for her phone because, as I mentioned, she cared about it quite a lot.
But you could have pulled up the iCloud website on your phone. Isn't that correct?
I suppose I could have. I was not aware of that being a potential option until much later.
And you could have used this website to find her phone.
Yes.
Yet when searching for the defendant's phone, neither of you remembered that fact.
Well, I have no cause to know that fact, and Avery, as I said, was extremely distraught.
Mr. Perkins, I'm not asking about whether or not you had a clause to know that fact. I'm asking about whether or not you remembered that fact when you were searching for the defendant's phone.
Objection, Your Honor.
You didn't, correct?
Let's, I'm sorry, restate the question and then you can state your objection before the witness answers.
Yes, Your Honor. When searching for the defendant's phone, you did not remember that fact, correct?
And what's the objection?
Asked and answered.
Response?
Your Honor, Mr. Balkins did not answer my question. He said that he did not have a reason to know that. However, that is not a yes or no answer about whether or not he did know that and whether or not he remembered it.
Okay. Overruled on the objection. Continue.
Now, when you were searching for the defendant's phone, you didn't remember that fact. Isn't that true?
Oh, yeah, that is true.
So you just tried texting and calling her phone instead.
Yes, that is also true.
Your Honor, no further questions at this time.
Any redirect?
Yes, Your Honor. Now, Mr. Perkins, it was mentioned that Avery Becker was egotistical and high-tempered. Does this mean that she would do something as rash as kill anybody?
No, and furthermore,
Your Honor, this asks for speculation.
Response?
Your Honor, as he has previously testified, Mr. Perkins was very close with Miss Becker and would have known whether or not her ego or her temper would have allowed her to kill somebody.
Okay, I am going to sustain the objection. I think that is speculation. Proceed.
Okay. Mr. Perkins, it was also brought up as to whether or not you used the Find My iPhone, like my iPhone on iCloud. Did you know of this existence?
I did remember of it later. However, it was not directly on my head because I actually do not own any Apple devices.
Thank you, Your Honor. No further questions.
Any recross?
No recross, Your Honor.
Okay, Mr. Perkins, you are excused. And defense, next witness.
Your Honor, the defense would like to call Professor Blake Van Owen to the stand.
Great. Welcome, Mr. Van Owen.
And before I start, Your Honor, may I request a time check?
Just over 12 minutes. Just under 12 minutes.
Yeah, 12 minutes and 12 seconds I have.
Thank you. Good evening.
Good evening.
Can you please state your name for the court?
My name is Professor Blake Van Owen.
And why are you here today, Professor?
Well, the defense has wisely chosen me on their behalf to opine what really happened in this case based on my long-lasting experience analyzing crime scenes and cell tower data.
You mentioned experience in cell tower data. Have you testified as an expert in relation to that?
Yes, I have testified as an expert in that area 5 times.
Please tell us about your expertise in crime scene analysis.
Sure. My background as a private investigator best exposed me to studying crime scenes. I have also attended various CSR conferences and have testified in crime scene reconstruction 8 times.
And do you have any education in these fields?
Yes, absolutely. I have a master's degree in criminal justice through Ashford University's online program.
Now, Professor, have you had any experience in law enforcement?
Yes, it began when I joined the Aurora Police Department. I eventually left, however.
What career paths did you take after you quit?
I pursued fields related to police work like private investigation, and now I am a professor at CU Denver for 5 years and counting.
And what have you taught as a professor?
I have taught in the areas of police practices and social justice.
Thank you, Professor. Your Honor, pursuant to Rule 702, the defense would now like to enter Professor Blake Van Owen as an expert in cell tower data analysis, crime scene reconstruction, and police practices through knowledge, experience, and education.
Any voir dire?
Yes, Your Honor. Good evening, Professor Van Owen.
Good evening.
You used to be a police officer, correct?
Yes, I was.
But you left the police force after just 9 months, is that correct?
Yes, I was disillusioned with the tactics used when arresting.
And you have not worked as a police officer since?
Excuse me, could you repeat the question?
You have not worked as a police officer since your 9 months, correct?
Well, technically, I have not worked as a police officer. However, I have taught a course on police practices and have pursued fields related to police work.
So that is a yes.
Yes.
You have testified as an expert in cell tower data analysis only 5 times, correct?
Only 5. I'd say 5 times is actually some very good experience for me. And yes, if to answer your question, yes.
Okay. And you have only testified for crime scene reconstruction 8 times, correct?
8 times.
So that is a yes. You do not have any other experience in these 2 subjects, do you?
I have had yes, I have had experience in terms of testifying in court, which I believe is very valuable. Analyzing real-time statistics, real-time data. So yes.
Professor Van Owen, but besides these testimonies, you have no other experience, correct?
You can say that.
So that's a yes.
Yes.
You also have no specific training in these subjects?
I've had a lot of education in these subjects, so.
But no specific training, Professor Van Owen.
Specific training, no.
You also have no specific education besides your master's degree, correct?
It is a master's degree, but yes, in criminal justice, specific training.
So that is a yes. Your Honor, at this time, I do not object to Professor Van Owen being entered as a expert in police investigation. However, I do object to him having a specialization in crimes in cell tower data analysis as well as crime scene reconstruction. Professor Van Owen does not have the required experience, skill, knowledge, training, or education required under Rule 702 to be classified as such.
Any response?
Yes, Your Honor. Professor Van Owen has testified in cell tower analysis 5 times and crime scene reconstruction 8 times, meaning that he has worked in both of those fields 5 times and 8 times, giving him more than enough experience to qualify as an expert in those fields.
Any reply?
Your Honor, besides this little experience, there is no foundation laid that Professor Van Owen has the required experience, knowledge, training, education, or skill in these subjects.
I'm gonna allow the testimony. Go ahead.
Now let's talk about the case at hand. What was your role in this case?
The defense chose me to conduct a private investigation on their behalf, including the areas that were neglected.
Given your investigation and past experiences, is there anything in this case that stands out to you?
Oh boy, there were a lot of overlooked facts, but if you put it together, it is quite obvious that the prosecution rushed this investigation.
And can you elaborate on that?
Sure. I reviewed all of their reports, and it seems really clear to me that they just zeroed in on one witness and a few ways that this murder could have occurred. Meanwhile, there are other more plausible scenarios.
And do you personally have any theories as to how this murder took place?
Yes, I have 2, in fact.
What's your first one?
This involves Blair Rollins and Alex Cifuentes. Essentially, Mr. Cifuentes takes Ms. Becker's phone from the fry shack on March 5th, creates fake text messages, then gives it to Blair Rollins, who takes the phone to the crime scene and murders Mr. Brackman.
In your scenario, why would Mr. Cifuentes give Mr. Rollins the phone?
From my understanding, Mr. Rollins and Mr. Cifuentes are close friends.
Can you tell us about your second theory?
In this, Blair Rollins essentially does everything. He takes the phone on March 5th, once again, brings it to the scene to implicate Ms. Becker, and murders Mr. Brackman.
In your opinion, why do you think the assailant is Mr. Rollins?
Well, his father, Jonathan Rollins, was defended by Mr. Brackman in a trial for murder, and they lost. This, in theory, would cause Blair Rollins to feel somewhat vengeful towards Mr. Brackman.
What else makes Mr. Rollins a potential suspect?
He was absent from school on March 6th, the day of the murder.
Now, Professor, let's talk about the murder weapon. Did you analyze its dimensions?
Of course I did.
And if I showed you the knife with its dimensions, would you recognize it?
I would.
Your Honor, permission to show Exhibit 6 to the court?
Granted.
Mr. Narayan, if you could share your screen. Thank you. Now, Professor, what is this?
These are the dimensions of the murder knife.
And is this an accurate copy of the exhibit?
Certainly.
Your Honor, at this time, I move for the admission of Exhibit 6.
Any objection?
No objection, Your Honor.
Exhibit 6 is admitted.
Now, did anything stand out to you about it?
Well, the knife's dimensions were inconsistent with the empty slot found in Mr. Brackman's knife block.
Now, Professor, is there anything else that stood out to you about the knife?
Also, its brand was completely different from the knife block that Mr. Brackman owned, which was from J.A. Henkel's.
Why is this significant?
This makes it much more likely that this was a planned murder in which the intruder brought his or her own knife.
When analyzing the weapon, what's the most common way of holding it while murdering someone?
The most common way to hold it is to hold it in a downwards angle, as that's the most natural way. If held the other way, it feels less natural. And in this case, it was obviously held downwards.
And what does that grip indicate as to the way Mr. Brackman was stabbed?
This is consistent with the victim sitting and the knife being thrusted into his aorta, or more simply put, his upper back.
And if I showed you a picture of the knife grip, Exhibit 21, would you identify it?
I would.
Your Honor, permission to show the court Exhibit 21.
Granted.
Now, Professor, what is this picture of?
This is a demonstration of the knife grip that I just mentioned.
And is it a fair and accurate copy?
It is.
Your Honor, at this time, I move for the admission of Exhibit 21.
Any objection?
No objection, Your Honor.
Exhibit 21 is admitted.
Now, we learned that the cell towers I'd like to move on, Professor. We learned that the cell towers traced Miss Becker's phone to the victim's house. How did the cell towers log Miss Becker's phone's connection?
Well, every time Ms. Becker received a call or text, which was from Mr. Perkins at the time, the cell tower that the phone is connected to keeps track of what time and place they were sent.
And how do these texts and calls correlate with Miss Becker's and Mr. Perkins' testimony?
This correlates with them calling and texting Ms. Becker's phone in an effort to locate it.
Now, on the topic of cell towers, I'd like you to turn your attention to the cell tower records.
Your Honor, I apologize for interrupting, but what all timekeepers has just, his computer just disconnected him from the meet, so his timing will be off.
Okay. So we have two timekeepers, right? Is your timekeeper Mr. Feiger or Ms. von Minden?
Yes, Your Honor, it's Mr. Feigl.
Mr. Feiger, okay. And it looks like Ms. von Minden is still keeping time, correct?
Yes, Your Honor.
Okay. Any objections to us just continuing with Ms. von Minden's time?
No, Your Honor.
No, Your Honor.
Okay, let's proceed.
Now, Your Honor, permission to show Exhibit 15, which was previously admitted as evidence. It was admitted by Detective Markowitz, Your Honor.
I'm sorry, can you ask the question again?
Yes, Your Honor. May I, can Mr. Narayan share his screen to Exhibit 15?
Yes, yeah, and for future reference, for everybody, if it's been admitted, go ahead and share it. You can use it however you want.
Now, Professor Van Owen, do cell phones always connect to the nearest tower?
No, in fact, they usually connect to the tower providing the best connection, which, remember, is not always the closest tower.
And when you analyzed this tower records for March 6th, where were Mr. Perkins' texts and calls relayed from?
They connected to 3 different towers and were relayed from the mall and the fry shack.
Why do you think the phone connected to 3 different cell towers?
Well, because Ms. Becker and Mr. Perkins were at the mall next to a busy highway, that would cause the cell towers to be experiencing a lot of traffic. Therefore, the cell phone would want to connect to multiple towers at different times, depending on when they provide the best connection.
Now, Professor, what does this evidence suggest altogether?
This corroborates that Ms. Becker did not have possession of her phone and was looking for it where she last left it, the mall and fry shack.
Finally, can you explain in layman's terms what really happened on the day of the murder?
Absolutely. While Ms. Becker and Mr. Perkins were at the mall looking for Ms. Becker's phone, Mr. Rollins brought his own knife to Mr. Brackman's home and, to Mr. Brackman's surprise, fatally stabbed him in the back.
Mr. Narayan, you may stop sharing your screen. Thank you, Professor Van Owen. That'll be all, Your Honor.
Cross?
Yes, Your Honor. Before I begin, may I ask for a brief time check?
You have 4 minutes and 45 seconds.
Thank you. Professor Van Owen, because of my small amount of time, I would appreciate if you would keep your answers to just yes and no.
I'll try.
Thank you. Let's begin by talking about your client, Ms. Becker. You say that GPS data is not the same as cell tower data, correct?
Yes, because it's not effective in tracking the person, only the phone.
Thank you. Thank you. Now, you use cell tower data to corroborate that Mr. Perkins was in fact at the mall on the day of the murder, correct?
Along with Ms. Becker, correct.
Yes, but there is no proof that Ms. Becker was with Mr. Perkins besides Mr. Perkins' word, correct?
Well, there's extensive evidence pointing to it. For instance, Miss Becker was at the fry shack the mall, as the cell tower is connected to her phone.
The cell tower is only connected to Mr. Perkins' phone at the mall, correct?
Yes, in that sense. I said yes.
Now, yes, thank you. Now let's move on to your theories about today's case. You say that your theory is that there was no, you say that Mr. Brackman was stabbed from behind, correct?
Yes, in a downward angle.
Yes, but for this to be true, Mr. Brackman would have had to not have been notified by his Ring doorbell at all, correct?
Yes, and there are multiple cases in which this could occur. The phone could have been in another room. He could have had the notifications disabled. And by the way, I know about all of this because I myself own a Ring doorbell.
Regardless of this, you saw the Exhibit 12, correct? The video of the intruder breaking into Brackman's back door, correct?
Yes.
And in this video, you heard an audible door opening and closing, correct?
Yes, I did.
Now, Mr. Brackman would have had to have not heard that at all for your theory to be correct.
Yes, I mean, you wouldn't. I don't think we have to speculate on this matter. Usually he would not hear it, I believe.
Now, the dining table where you allege Mr. Brackman was stabbed is 5 feet from the back door, correct?
That is not in my testimony, but you guess so. Yes.
But you have reviewed all other testimonies as well as the other expert reports, correct?
It was never in my written testimony, but that is correct.
But based on other reports, it is correct.
Yes.
Now, your theory is that Mr. Brackman did not make any move after he heard this door, correct?
Yes, because typically sliding doors are quite silent, so usually he would likely never hear the door or the perpetrator entering, and therefore it was caught by surprise.
But you have heard this door open in this video, correct?
Yes, in the video, since the doorbell's right next to the door.
Thank you, Your Honor. No further questions.
Any redirect?
Yes, Your Honor. Now, Professor, the perpetrator closed the door, back door, as Mr. Bloom explained. Why do you think he did that? Or he or she did that?
Sorry, could you repeat the question?
Sure, sorry. Why do you think the perpetrator closed the door?
Because the perpetrator would never want to never make it obvious that he entered the home, and in order to make Mr. Brackman surprised.
Thank you, Professor Van Owen. That'll be all, Your Honor.
All right, any recross?
No recross, Your Honor.
All right, Professor Van Owen, you are excused. And does the defense have any more witnesses?
No, Your Honor, the defense rests.
All right, is everyone ready for closing arguments?
Yes, Your Honor.
All right, prosecution, you may proceed.
I would just like to renew my request to reserve any remaining time for rebuttal.
Yeah, so, and this is where I'm going to break character a little bit. In the rules of mock trial, is it acceptable to have a generalized, anything I don't use is reserved for rebuttal, or are you required to actually state a specific time?
I believe I can just reserve any remaining time for rebuttal after my closing argument.
Okay, we will go ahead and do that. Typically, in my experience in a courtroom, during oral argument, you have to say, I reserve 2 minutes, and then you're tied to that. But let's go ahead and do that according to your rules. Please
Thank you, Your
proceed.
Honor. Ladies and gentlemen, today's case is about someone who pushed the limit again and again until finally they went too far. That someone is the defendant Avery Becker, an entitled student who would lash out in ways that even her close friends described as rash when she didn't get what she wanted. On March 6th of 2020, after the defendant's mock trial coach, Mackenzie Brackman, kicked her off the mock trial team, the defendant just couldn't stop. Enraged and with her pride tarnished, the defendant vowed to get back at Mr. Brackman if it was the last thing she did. But this time, it wasn't just petty vandalism. It was burglary that ended in murder. On March 6th of 2020, the defendant broke into Mr. Brackman's home and stabbed him to death. Today, the defendant is being charged with burglary in the second degree and murder in the first degree. Pursuant to Colorado Criminal Jury Instructions number 7 and 8, in order for the defendant to be found guilty, the prosecution must prove beyond a reasonable doubt that the defendant unlawfully entered Mr. Brackman's home with intent to vandalize and stabbed him in the back with a kitchen knife, leaving him to bleed out on the floor. The evidence you heard today leaves absolutely no doubt. The defendant went too far. It all started when the defendant couldn't hold her tongue at mock trial practices. Recall that while Mr. Brackman was a caring coach who just wanted to help the defendant improve, the defendant took personal offense to this critique and would ruthlessly put her coach on blast at every single mock trial practice. You even heard the defendant admit that she believes Mr. Brackman wouldn't know a good cross-examination if it hit him over the head, despite Mr. Brackman's countless years as a defense attorney himself. You then heard about when Mr. Brackman's exasperation with trying to help the defendant came to a head following months of disrespectful behavior, leading to the defendant being rightfully demoted to the B team. In a fury, the defendant then left mock trial practice with a Sharpie in hand to go vandalize Mr. Brackman's vintage Porsche Carrera, but not before petulantly screaming in his face and calling him the worst coach in the state. When Mr. Brackman saw what the defendant had done to his car, he did something the defendant was lucky hadn't happened months prior. He kicked the defendant off the mock trial team. Desperate to get back on the team, the defendant then texted Alex Fuentes and divulged her plan to break into Mr. Brackman's home and trash the place. But the defendant didn't just break in and vandalize. The defendant went to Mr. Brackman's home, found him inside, initiated a violent struggle between the two of them, and ultimately stabbed Mr. Brackman in the back, leaving him to bleed out on the floor. The defense spent their time crafting an alternative theory that someone other than Avery Becker stabbed Mr. Brackman. But let's review the evidence. You learned about the call detail records that placed the defendant's phone at the scene of the crime precisely when the murder occurred. You learned about the phone being tracked along Rock Creek Parkway, which would be the most logical route for one to travel from the defendant's home to Mr. Brackman's home. You also learned about the Ring security camera footage, in which the defendant herself even admits has the same heightened build as the individual unlawfully entering Mr. Brackman's home that Friday, March 6th. Finally, you learned about the physical evidence at the crime scene, in which Kyle Kuzak concluded that the stabbing was done in haste, which would be consistent with Ms. Becker showing up to Mr. Brackman's home and not anticipating him to actually be there. The prosecution has proven that on March 6th of 2020, the defendant broke into Mr. Brackman's home with intent to vandalize and stabbed Mr. Brackman in the back, leaving him to bleed out on the floor. The defendant was not able to stop herself, but you members of the jury can stop her and hold her accountable for the murder of Mackenzie Brackman. With that, there is no choice but to find the defendant guilty of burglary in the second degree and murder in the first degree. Thank you.
All right, defense?
Your Honor, members of the jury and opposing counsel. My name is Terry McDermott, and myself and my co-counsel represented Avery Becker. Negligence leads to ruined lives. And throughout this case, you have seen that the prosecution has been cherry-picking facts based on what they want this case to come to, but not what this case should come to. They claim that the only option, the only person who could have murdered Mr. Brackman was Avery Becker, and this is simply not true. In order for the prosecution to prove this, they must prove every element of the crime beyond a reasonable doubt. Reasonable doubt is a doubt that is founded upon reason or common sense, that is based upon the evidence or lack thereof. Now, members of the jury, the prosecution claims that they followed through the evidence, but they simply have not. They claim that Taylor Perkins is such good friends with with Avery that he would lie for her, and this is simply not true. Taylor Perkins was a part of the mock trial team. He knows what would happen to him if he lied, so why would he? And they claim that Avery Becker was at Taylor's house. Avery didn't have her phone. And even if she did, she didn't know where it was. The prosecution claims that they've thought through the investigation, but really it was just negligent. They have failed to notice or to inform you that the victim's hands moved, that the person intruding closed the back door, and many others. And while this may seem it's not important, it is, as it shows, as it's not for them to choose whether something is important. It's for you, the jury, to choose. The prosecution claims that this is a feud that has gone too far, but it's not the feud between Avery and Brackman that has gone too far. is the feud between Blair Rollins and Mr. Brackman. Blair Rollins has a much bigger motive for this murder. His dad was sent to jail, and Mr. Brackman was the one who was in charge of his trial. That is a much bigger motive than being kicked off a mock trial team. So, members of the jury, I'm asking you to come to the verdict that Avery Becker is not guilty, because the prosecution's investigation was negligent, and negligence leads to ruined lives. And if Miss Becker is seen as guilty, her life will undoubtedly be ruined. She will not be able to make the difference that she was meant to make, whether that is a big difference or a small one, whether that difference affects one person or a whole community. Now, members of the jury, I want you to remember that it wasn't that Miss Becker is presumed innocent unless there's no reasonable doubt about whether she was the one that committed this murder. And can you not see that there's been reasonable doubt? So, members of the jury, I'm asking you to come to the verdict that Miss Becker is not guilty and let her live the life that she was meant to live. Thank you.
All right, rebuttal from the prosecution.
Yes, Your Honor. May I just request how much time I have remaining?
You have 1 minute.
Thank you. The defense just tried to tell you that this case is about poor conduct that led to a ruined life. But that poor conduct was not on the part of the prosecution. Avery Becker's rash decisions led to not a ruined life, but rather a brutal end to one when she stabbed Mr. Becker in the back and left him for dead. The defense's theory would like you to believe that you have to ignore all the hard evidence. They want you to ignore the call detail records, the text with Alex Fuentes, and the ring security camera footage. But the evidence doesn't lie. Today, you must find the defendant Avery Becker guilty of burglary in the second degree and murder in the first degree. Thank you.
Thank you. All right, everyone. Excellent job. I think that I've got a text from Kyle about 5 minutes ago saying, hey, could the scoring judges submit their score? So I'm thinking what maybe I'll do is I'll give comments to the teams while if you want to tabulate your scores and submit them, and then you can give comments if you'd like. Does that sound good? Awesome. Great job, everyone. Yeah, everybody turn your cameras back on. Excellent work. I've done a few judging or a few mock trial competitions. This is my first time being a presiding judge, but I've been a scoring judge for a few competitions before. It always amazes me that high school students can present themselves in a way that is more prepared and more professional and more on their toes than many lawyers I have seen in the courtroom. That says a lot. You guys have obviously been over these facts 1,000 times, and it was just a very impressive job. I took a bunch of notes. I don't know if I want to necessarily call anybody out individually. I think that you know, as I mentioned a couple of times, or I mentioned once during the trial, that if an exhibit is admitted, it's admitted. You could throw it up on the screen. You may have mock trial rules that go against that for Zoom, but typically, you know, once it's admitted, everybody uses it however they want. Cross-examination, I noticed that, and this kind of goes across the board when everybody was cross-examining. Great job in asking leading questions, leading people towards the answers. I think everybody could have been a little bit tighter on asking the you know, you're not just asking a leading question, you are boxing in the witness to give you the responses you want. And so it's less, isn't it true that this, because that still leaves it a little bit open, but very forceful, strong, controlling. Then you did this, didn't you? then you did this, didn't you? And isn't this true? This is true because, and so you're leading them down a funnel to the point that they have no other option but to agree with you. I know that particularly with experts, every expert always comes in. I think some of the witnesses probably would never actually be experts in a court of law, but everybody did great with voir dire. I think also this is something that probably runs up against your real world experience versus mock trial experience with voir dire. I think if you're not going to object to a witness coming in or to an expert giving opinion, then it's probably better not to do the voir dire. But I do think that for the purposes of mock trial, you likely have to. But the one time I noted it, and I don't have it immediately available, but the witness that had 19 years of experience and was overly qualified to be providing opinion, and then the voir dire kind of just solidified that. So a jury would look at that and think, yeah, this is the guy, no matter what he says, I'm believing, because the prosecution puts him up as having 19 years, and then the defense is saying, yeah, you got 19 years. You are an expert, aren't you? So if you don't have anything, I guess with a voir dire, if you don't have anything bad to say, don't say anything at all. What else? Let's see here. Everybody did a great job on both objecting, responding to objections. I'm sure it was obvious, but there at the end, I started sustaining more because I think everybody needed to, or rather was so good at objecting and responding that it kept you a little bit on your toes to then have to reposition yourself after you couldn't continue on the line of questioning that you were anticipating. And you guys did a great job of that when you couldn't continue on that line of questioning. That's all I have. Scoring judges, do you want to give comments?
I guess I would just say great job to all of you. This is such a crazy time for attorneys in general. And all of you adapted. I mean, having to wait for exhibits to come up. Believe it or not, that's going on in courtrooms right now, real courtrooms with real hearings, and you're handling it better than some attorneys in the moment, and frankly, some judges in the moment. So I think we can learn a lot from youth in that way. I would say one thing to really watch is fillers. I do them. We all do them. You know, whether it's women twisting your hair, saying, but you fall into the traps. I think, you know, when you're nervous, you can fill it. And it's just as important when you're laying out your questions. I have never worked from a script, and plenty of attorneys have. I work from bullets. I like figure out what are the bullets I need. Otherwise, you get into the habit of saying, let's talk about this, or you just said, and you fill in the gap instead of staying in control. So especially on cross, if you can say, what are the 5 or 4 or 3 salient points I need, and just get in and get out, go after those, hammer those, but don't let the witness take you all astray. Experts are notorious for it, but just stay in control and stay focused on what you want. On direct, I think you all did a great job of telling the story. And then on cross, you knew what you wanted to get, and sometimes things would throw you off. That happens in court every day. It happens to all of us. So you all stayed in character. Your witnesses were excellent. They really helped you along. So hats off to you, and I want to commend you for your courage. I'll show my age here. We didn't have mock trial in my high school. We had debate, and I don't know if I would have had the courage. I'm in the courtroom every day now, but I am really proud of all of you. So good job.
I'll go next. I just want to say that I was very impressed with how prepared everyone was, and everyone's composure with going through this process. It's very nerve-wracking. I thought everybody was well prepared with their objections and their responses to those objections. I thought a lot of you guys did a really good job with your organization, with your direct examinations and your crosses, and making sure that you were kind of giving direction with where you were going and leading the witness the way you wanted them to go. I would agree with Judge Helm about the closing those cross questions a little bit more when you kind of basically just use a statement instead of using a very narrow question. That gives that witness a lot of leeway. So you want to be very careful with that. Let's see. Again, I just think you guys did great. The only other note I have is be careful with interrupting witnesses. You want to make sure that you're respectful of the witness on the stand, and you also want to make sure that you preserve a good record. Because a lot of times when you're in court, the audio tape recorder can't make out what's being said if two people are talking at one time. So you always want to be respectful of that. But overall, great job. I was very impressed. It was my first mock trial. First mock trial competition to judge, and it was very exciting.
And I'll just say as well that I'm very impressed by how well you all did, how prepared you were. I've judged these competitions for a couple of years now, and I just wanted to say that I was impressed by the way that you knew the material and that you were ready with your objections, and also that a lot of you were very confident in arguing your objections, because sometimes when you get in that position, you can kind of freeze up. But I felt like you guys displayed a lot of confidence in handling those objections. Both sides, I thought, did a really good job of kind of telling their story, right? The prosecution kind of explaining how it was that she could possibly murder someone, and then the defense offering up the alternative suspect. The one thing that I would have really loved to have heard more of is just the distinction between scribbling on a car and murder, and the violent act of murder. I know that the prosecution really tried to have it come across that the defendant was acting rashly, right? But I think that the defense could have done more to try to say, well, does it really make sense that she would resort to murder? Like, even if she had intended to ransack the home, if she had walked in and been confronted with him, the coach with the knife, would she have actually grabbed the knife and tried to kill him, or would she have reacted differently? And I think, those kinds of points where you really try to make the story make sense, that's really compelling to a jury when you're just trying to tie all your evidence together. And that would be my only constructive criticism. I think you guys did an awesome job, and thanks for letting me witness this.
Yep, thanks everyone. Good luck. I don't know if you move on from here until tomorrow, but good luck from wherever you go. Have a great night.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your